Three petitioners have moved to court to challenge the ongoing bipartisan talks under the National Dialogue Committee, claiming that the process is illegal and unconstitutional. The petitioners are accusing the committee of not involving the public in coming up with the issues for amendment of the Constitution. They argue that the issues listed by the committee are politically driven. The petitioners want the court to stop the committee from considering issues for the amendment of the Constitution in a move that may deal a major blow to the talks at Bomas of Kenya. Serafin Achieng-Ouma now reports.
The National Dialogue Committee, co-chaired by Wiper Party leader Kalonzo Musyoka and Kikuyu Member of Parliament Kimani Ichung'wah, took a break from its sittings on Friday, but developments mean its fate is uncertain after three petitioners moved to court to challenge its constitutionality and legality. Isa Ilanyi Chamao, Patrick Karani Ekirapa and Paul Nyangweso Kirui argue that there is no legal framework to guide the process of amending the Constitution by the committee, which has outlined issues for possible amendment without a background analysis or audit of the Constitution to identify gaps. They are also poking holes on the procedure that was adopted by the committee to arrive at the issues for amendment of the Constitution, claiming that they did not involve the public and are politically driven. The petitioners state, and I quote, "The respondents cannot cherry-pick and lemon-sell issues for constitutional amendment from the ivory towers of the Bomas of Kenya while sipping expensive champagne and tea." End of quote. They have cited lack of a legal framework to guide the collection of views from members of the public in an inclusive and participatory process and short timelines in collection of views on pertinent issues that have a bearing on amendment of the Constitution. They argue that the 7-day period issued by the National Dialogue Committee to collect views from the public is too short to gather views on pertinent constitutional issues. The petitioners have also raised concern with what they term as the omission of important stakeholders, such as the Law Society of Kenya and civil society in general, in the composition of the committee. The petitioners are seeking conservatory orders to stop the National Dialogue Committee from considering issues for the amendment of the Constitution and drafting amendments to the Constitution of Kenya. They want the court to stop the clerks of both the Senate and the National Assembly from using public funds to support the committee and its secretariat. The petitioners have listed the 10 members of the Dialogue Committee, the National Assembly and the Senate, together with the Attorney General as respondents in the case, and IEBC, Law Society of Kenya and Katiba Institute as interested parties. If the court issues the prayers sought by the petitioners, the move will likely deal a blow to the process that is driven by the committee, which had on 1st September 2023 invited views from the public on 13 key issues, among them the cost of living, the implementation of the 2/3 gender rule, promoting national unity and inclusivity in public appointments, adequate checks and balances, restructuring and reconstituting IEBC, as well as auditing the 2022 presidential election. Justice Lawrence Mugambi has ordered that the application be served within 7 days and that responses be filed and served within 7 days of the date of service. The petitioners may file a rejoinder within a further 7 days, with mention set for the 23rd of next month. Meanwhile, a showdown is looming as two factions of the Jubilee Party are expected to appear before the committee next week, among other players who will be presenting their views before the sittings conclude on Tuesday. Serafin Achieng-Ouma, Citizen TV.